to falsify business records with intent to defraud and an intent to conceal another crime. That is exactly what this case is about. 34 false statements made to cover up other crimes. These are felony crimes in New York State, no matter who you are. We cannot and will not normalize serious criminal conduct. The defendant repeatedly made false statements on New York business records. He also caused others to make false statements. The defendant claimed that he was paying Michael Cohen for legal services performed in 2017. This simply was not true. And it was a false statement that the defendant made month after month in 2017. April, May, June, and so on through the rest of the year. For 9 straight months, the defendant held documents in his hand containing this key lie, that he was paying Michael Cohen for legal services performed in 2017. And he personally signed checks for payments to Michael Cohen for each of these 9 months. In total, the grand jury found there were 34 documents with this critical false statement. Why did Donald Trump repeatedly make these false statements? The evidence will show that he did so to cover up crimes relating to the 2016 election. Donald Trump, executives at the publishing company American Media Incorporated, Mr. Cohen, and others agreed in 2015 to a catch and kill scheme. That is, a scheme to buy and suppress negative information to help Mr. Trump's chance of winning the election. As part of this scheme, Donald Trump and others made 3 payments to people who claimed to have negative information about Mr. Trump. To make these payments, they set up shell companies, and they made yet more false statements, including, for example, in AMI, American Media Incorporated's business records. One of the 3 people that they paid to keep quiet was a woman named Stormy Daniels. Less than 2 weeks before the presidential election, Michael Cohen wired $130,000 to Stormy Daniels' lawyer. That payment was to hide damaging information from the voting public. The participant scheme was illegal. The scheme violated New York election law, which makes it a crime to conspire to promote a candidacy by unlawful means. The $130,000 wire payment exceeded the federal campaign contribution cap, and the false statements in AMI's books violated New York law. That is why Mr. Trump made false statements about his payments to Mr. Cohen. He could not simply say that the payments were a reimbursement for Mr. Cohen's payments to Stormy Daniels. To do so, to make that true statement, would have been to admit a crime. So instead, Mr. Trump said that he was paying Mr. Cohen for fictitious legal services in 2017 to cover up actual crime committed the prior year. And in order to get Michael Cohen his money back, they planned one last false statement. In order to complete the scheme, they planned to mischaracterize the repayments to Mr. Cohen as income to the New York State tax authorities. The conduct I just described and that which was charged by the grand jury is felony criminal conduct in New York State. True and accurate business records are important everywhere, to be sure. They are all the more important in Manhattan, the financial center of the world. That is why we have a history in the Manhattan DA's office of vigorously enforcing white-collar crime. My office, including the talented prosecutors you saw at arraignment earlier today, has charged hundreds of felony falsifying business records. This charge, it can be said, is the bread and butter of our white-collar work. And fraud presents itself in all different forms here in Manhattan. We have charged falsifying business records for those who violated federal bank secrecy laws. We have charged falsifying business records for those who were seeking to cover up sex crimes. And we have brought this charge for those who committed tax violations. At its core, this case today is one with allegations like so many of our white-collar cases. Allegations that someone lied again and again to protect their interests and evade the laws to which we are all held accountable. As this office has done time and time again, we today uphold our solemn responsibility to ensure that everyone stands equal before the law. No amount of money and no amount of power changes that enduring American principle. I'll now take questions.
Mr. Bragg.
So we're going to take a limited number of questions. There are no follow-up questions. One question per reporter. I will call on you. And again, we have limited time. Thank you. The first question will be Brett.
Mr. Bragg, thank you. Brittany Russell, CNN. Why now? I mean, some argue that this is a political move. You're not going to be a political person. The court dates are going to go into
We conducted a thorough and rigorous investigation, as we're known to do, at the Manhattan District Attorney's Office. I've been doing this for 24 years and am no stranger to rigorous, complex investigations. I bring cases when they're ready. Having now conducted a rigorous, thorough investigation, the case was ready to be brought, and it was brought.
Mr. Bragg, the indictment says that there were 34 false business records. And they would then conceal another crime, but the indictment does not specifically say what those crimes were. We are assuming, perhaps, that they might be election-related. I'm wondering if you can specify what laws were also broken.
Sure. So let me say as an initial matter that the indictment doesn't specify that because the law does not so require. In my remarks, I mentioned a couple of laws, which I will highlight again now. The first is New York State election law, which makes it a crime to conspire to promote a candidacy by unlawful means. I further indicated a number of unlawful means, including more additional false statements, including statements that were planned to be made to tax authorities. I also noted the federal election law cap on contribution limits.
But why weren't there those crimes charged? Why wasn't he charged with those crimes?
Well, I'm not going to go into our deliberative process on what was brought. The charges that were brought were the ones that were brought. The evidence in the law is the basis for those decisions.
Hi, Mr. DA. You had expressed a year ago that you had some reservations about the case's readiness. Can you talk to us about what were some of the questions in your mind that needed to be answered in order to bring a case of this magnitude?
I'm not going to go chapter and verse into any thinking. What I will say is, I believe the time period you're talking about, I've been in office for a couple of months. The investigation, in my view, was not concluded into the conduct in particular that is the basis for the charges today. Since that time, we've had more evidence made available to the office and opportunity to meet with additional witnesses. So as I said earlier, I've been doing this for 24 years. I don't bring cases prior to a thorough and rigorous investigation. Now, having done so, the case has been brought.
Mr. Bragg, Garrett Hake with NBC News. Your predecessor took a hard look at this case and decided not to charge it. Federal prosecutors took a hard look at this case and decided not to charge it. Do you believe you have new evidence that led you to decide to charge this, or why now?
Well, as I just mentioned, we have had available to the office additional evidence that was not in the office's possession prior to my time here. And as to your part of your question about the federal, we have a distinct and strong, I would say profound, independent interest in New York State. This is the business capital of the world. We regularly do cases involving false business statements. The bedrock, in fact, the basis for business integrity and a well-functioning business marketplace is true and accurate record keeping. That's the charge that's brought here, falsifying New York State business records.
We're going to take two more. Yep.
Thank you. DA Bragg, I'm just going to read back one line from your statement of facts. The participants also took steps that mischaracterized for tax purposes the true nature of payments and furtherance of the scheme. You allege former President Trump was one of the participants who mischaracterized the payments for tax purposes.
I'm not going to go beyond the plain language statement of facts, which I think speaks for itself.
Dean Bragg, can you please comment on the strength of the evidence that Trump personally intended to violate state election law, including actions that are charged in the indictment?
So the charge is falsifying business records. The charge requires, as I specified, criminal conduct that was concealed. One of the concealed crimes we allege is New York State election law. I sort of went through in our statement of facts, which I think many of you have in front of you, goes through things including, text messages, emails, contemporaneous phone records, multiple witnesses. All of that will be, as you saw in the fall, borne out in a public courtroom in downtown Manhattan.
Last question is Jonah.
Yeah, Greg, the charges related to the hush money payments to Stormy Daniels, the release from your office also mentions another woman, Karen McDougal, as well as a doorman. Can you comment on how those players are related to the charges you've brought or to the case overall?
I'm glad you put your finger on that, because it's not just about one payment. It is 34 business records, 34 false statements in business records, and we're concealing criminal conduct. And the earlier question about New York State election law, when I talked about conspiracy to promote a candidacy by unlawful means, those unlawful means we allege include the conduct set forth in the statement of facts, which is additional false statements separate and apart from the charged ones in AMI documents, planned false statements to taxing authorities. It is not just that one $130,000 wire payment. Thanks so much.
Mr. Bragg, any comment about any incitement of violence by former president?
At what point do you think that order is necessary?
And we just heard from the Manhattan District Attorney Alvin Bragg outlining what is the new evidence, he said, that led him to bring this case before a grand jury. And, of course, these 34 indictments as the president was arrested, booked, and pled not guilty today. Ricky Kleeman, quickly on that point, not only that he falsified business records, but something else we just heard at the tail end there that could be significant.
Well, because Alvin Bragg is saying that in this conspiracy to promote a candidate by unlawful means, that one of those things was that it affected the tax authorities. So the question was, how did the false statement become a tax violation? Well, it's accounted for as a business record because it's a legal fee, and that was not true.
Let's bring in Scott Fredrickson, former prosecutor who's been listening as well. What did you learn from those words by the district attorney and the indictment?
Well, we learned a lot here finally today. This is a powerful indictment. It's no longer just the Stormy Daniels affair and the payoff. It's a scheme. It's a scheme to catch and kill. It's executed by meetings at Trump Tower. There's 3 parties to it. The CEO of American Media, Michael Cohen, and it says 2 of the parties have pled guilty. It describes the shell companies, the payoffs, and it even describes then when in the White House, after having been elected, the pressure campaign to prevent Mr. Cohen from cooperating. So I think you have to hand it to the DA. They put together a powerful statement of evidence that no defense attorney would want to have to defend against. I think the other critical question here is the legal theory still the same? Because now they reference mischaracterization for tax purposes and state election law. Before, we thought it was just the federal election law. Will that carry the day? In the end, the defense still, its best opportunity here will be try to knock this case out on a motion to dismiss. If they have to go to trial against this, there's an explosive list of the meetings, the payoffs, the campaign to pressure, the guilty pleas by those involved in the agreement. That's a scheme they describe. It's a strong case.
All right, let's bring in Jerry Goldfeder, who also looked at this and is a campaign finance lawyer. Jerry, what did you learn?
Well, I think that our speculation over many weeks has been borne out. The false records has been tied to alleged election law violations. And I think if in fact this indictment does survive a motion to dismiss, the jury will see a lot of texts, will see documents, and we'll hear from multiple witnesses. And I think reading the facts as presented by the district attorney, it's not going to just be Michael Cohen. It's going to be a variety of people. And the question will be for the jury as to whether or not District Attorney Bragg will be able to prove by beyond a reasonable doubt whether or not all these facts constitute activity that's in furtherance of his presidential election. He's going to defend himself and say it's not, but we're going to have a tremendous number of documents, and we're going to have testimony to tie this business records charge to the presidential campaign. That's what makes it a felony.
Jerry Goldfeder, thank you. And Jeff Pegues, some of the criticism made by Trump's team has been you can't base a whole case on Michael Cohen. You know, he's a felon. He's served time. That's not going to hold up. But we learned there are additional witnesses, new evidence, and in the words of some here, this is a powerful indictment.
Yeah, I think what they've done is bolster their case with this witness testimony. Alan Weisselberg must have said something. Right?
We don't know yet.
Well, we don't know yet, but I think this is where this is heading. That may have been some of the evidence they have, in addition to what they have earlier, that really helped bolster this case. Because you're right. Michael Cohen, who was an insider, who was really close and loyal to Donald Trump.
The fixer.
He was the fixer, the special counsel title that he loves so much. I've talked to him about that over the years. But he does have credibility problems, right? Mm-hmm. So you have Alan Weisselberg. He's a guy that doesn't talk, right? He is...
The vault.
He's the vault. You know, back in the day when they prosecuted mob cases, they would have the accountant who wrote everything down, didn't say anything. You know, so for the Trump organization, Alan Weisselberg is the key. And if you look at all those people, Cohen, Weisselberg, Pecker, they have all suffered consequences as a result of crimes or alleged crimes related to all of this. So if they're going to point up at the big man when they go in front of a jury, I mean, what is a jury to think? Listen, he went down for this, he went down for this. Well, what about the guy that they were all doing it for?
When you look at this statement of fact, there's another piece of history here. So much of the facts detailed come in the first year and second year of Trump's presidency. While Donald Trump was president of the United States, commander-in-chief of the United States military, he was actively, according to this indictment and statement of fact, dealing in a criminal scheme to cover up payments he made with his associates during the 2016 presidential campaign. Checks being made in the Oval Office, detailing here a pressure campaign on lawyers to stay in line, all alleged in this indictment and the statement of fact. This is not just about the story of Donald Trump. It's a story about the American presidency being tested in a way we haven't really seen in a criminal sense since Richard Nixon.
The hardest job in the world, which of course is the title of John Dickerson's book. Did I say that correctly?
You did. God love you. Yeah.
But, you know, think about that, because it is, and to be dealing with all of these personal and salacious details,
right,
as is alleged by the district attorney.
Right. You should be dealing with other things. One thing that, and again, as you just pointed out, it's quite important to say this is what's being alleged by the Manhattan DA. But what the DA is alleging is not just, oh, here came this story from somebody and we got to clean it up because I'm embarrassed. The DA is alleging in August 2015 the entire catch and kill scheme was created as a place to put bad things that would hurt the election. It wasn't just some bad thing that happened close to the Access Hollywood tape coming out and it was a fast movement. It was, according to the DA, a long, planned out, methodical effort to subvert the electoral
The porn
process.
star, the Playboy model, the Trump Tower guy who said maybe there was another baby out there.
Right. And since all of that was paid by funds that were then lied about in official proceedings, that's how this entire big thing was, from its inception, according to the DA, a part of trying to get around the election or election related.
I think it's an interesting idea what the defense could be, which could be embarrassing personally. But what if the case is that Donald Trump and Michael Cohen had been doing this for years, long before the campaign, of paying off women, so that it would not be primarily about the campaign?
Wow, that's an interesting, in other words, they'd done it before, and so it wasn't a campaign finance violation.
Correct.
It would be.
I mean, I have no basis in fact for that, but I think it's an interesting defense if I were a defense lawyer, if in fact it's true.
Right. The motivation, it takes away the motivation.
Correct, which is the gravamen of the complaint.
Right. This was just a part of my personal hygiene, and I just happened at this point to be doing this thing that I'd done my whole life while there was a presidential campaign going on, but it wasn't initiated for the purposes of getting around.
Well, and that it is a defense, but of course it creates all kinds of other issues for Donald Trump.
All right. Well, thanks to all of you. This has been a fascinating and historic afternoon, and appreciate all of your reporting and terrific analysis. Just to recap, it was about an hour in court for the former President Donald J. Trump, where he pleaded not guilty to 34 felony counts of falsifying business records. The Manhattan District Attorney's statement of fact alleged it was part of an effort to conceal crimes that hid damaging information from the voting public during the 2016 presidential election. In the words of some, a powerful indictment that alleged a scheme by the former president of the United States so he could get elected president. Well, today, Donald Trump becoming the first former president to be booked, arrested, read his rights. He is now back on his way to Florida, where he will deliver remarks this evening from his home there and private club, Mar-a-Lago. We will continue on CBS News streaming your local news, and we will have a full wrap-up tonight on the CBS Evening News. A big thank you again to our team of our correspondents, reporters, guests, producers, and contributors. This has been a CBS News special report, the arraignment of Donald J. Trump. I'm Norah O'Donnell in New York.
Welcome back to CBS News. I'm Caitlin Huey-Burns. You've been watching a CBS special report on the history-making arraignment of former President Donald Trump. The former president has been booked, fingerprinted, and has pleaded not guilty to 34 charges. We have a team of contributors and correspondents covering all of this, and we're going to start with Jessica Levinson, who is a CBS News legal contributor and Loyola Law School professor, and she joins us now. Jessica, good to see you. Thanks for being here. So let's just start off the bat. What do you make of these 34 charges against the former president?
Well, a couple of things to think about. We keep saying 34